Good morning, everyone. Today is Tuesday, April 21st, 2020. It's approximately 10:15 a.m. Today, we're joined once again by the Family Law Matters legal panel as we discuss modifications in general. I'm going to give the panel an opportunity to introduce themselves, and then we'll dig into the topic. We have the frequently most asked questions, and we'll give each attorney an opportunity to answer this for you. I want to remind the participants that if you have any questions, please make sure that you send them to us via chat or via email. And if you're joining, please make sure that your computer and or telephone are on mute. Okay, so Gina, let's start with the introduction. Let's start with you.
Yes, I'm Gina Famularo, and I am one of the partners at Family Law Matters. I've been an attorney for 22 years, always in family law, and I've practiced in Riverside counties and Orange County my career.
Thank you, Gina. Kristy.
Good morning, everyone. My name is Kristy Bergamo. I am a family law attorney here at Family Law Matters. I'm a senior attorney here. I've been practicing 17 years, and I am also an instructor at the University of California, Riverside paralegal program. And finally, I've been certified to be minors counsel in the courts in Southern California.
Thank you, Kristy. Colleen.
Good morning, everyone. My name is Colleen Robinson. I'm a family law attorney here at Family Law Matters. I've been practicing family law now for 10 years, mostly in San Diego County as well as Riverside County, but I've appeared all over Southern California.
Thank you, Colleen. And I'm Bashor Shahada. I'm the moderator. I've also been an attorney for 2.5 years, and I'm the managing partner at Family Law Matters. So Gina, let's get to it. What is a modification?
Sure. A modification it can be a change of any permanent court order. Today, we're only talking about modification of custody and visitation. That is where there's an existing court order in place and one of the parties or both of the parties want to change those court orders.
And if that's the case, how does the party know that they're ready to go back to court?
Sure. When people come in and ask me that, that's a very common question that we get. How do I know if I need to go back to court? I typically look for two things, Bishoy. I look for orders that are so vague that there's no ability to determine what the intent is for the custody and visitation. So it opens the parties up to a lot of dispute as to the times or days that the children should be with the other party. And also I look for something that's changed. So either one of those could be a reason to go back to court. What we say in law is new or existing facts. For instance, let's say that the parties lived, 2 miles apart, and now the parties live 50 miles apart. Obviously, the original court orders are no longer possible, but it could be a number of circumstances that have changed over time that require the parties to go in and get new orders.
And what if I'm the party that don't want the change, but I've been served with paperwork? What do I do at that point?
Sure. So you obviously need to call an attorney and you need to have the attorney look over the paperwork. So the first tip here is if somebody is trying to change a court order, make sure you get a copy of the paperwork. Don't play games and hide and assume that if you don't receive a copy of the paperwork, that the other party's not going to be able to change the court orders. And then when the attorney looks over the paperwork, what they're going to be looking for is, does this meet the legal standard? Does it qualify as a reason to modify the existing orders? And depending on how the order was obtained, the type of order, it will depend upon whether or not there's going to be an adequate factual reason to be able to change the court orders. And then even then, you still need to get an attorney because custody is based upon what's best for the children. The court's looking for stability and continuity, but they're also looking for safety and a whole bunch of other factors that go into the mix when you're talking about what's best for the children. So when you have an attorney, we can present the facts to the judge in a way that is going to be most favorable to your position.
And just so we're clear, what is the legal standard?
Sure, it depends. Let me just say that. But as a general rule, it's going to be, as we kind of talked about, it's going to be something that is so vague that it needs to be clarified. You're not necessarily changing the orders, you're clarifying them, or there's something new or different. Something has changed. Depending on the type of order and what we're talking about, typically what we would look for is what we call a significant change of circumstances. Now, that's not necessarily the legal standard, but it is our rule of thumb when we as attorneys look to the facts to see whether or not an order should be modified.
So if I'm the custodial parent and the non-custodial parent does not see the child, do I have to go back to court?
It depends.
Okay.
You might need to. It would depend upon what the other party's visitation is. It would depend on why they're not seeing the child. It would depend on what orders you're wanting to modify. It would depend on whether you're wanting to change schools or change residence or clarify orders. Perhaps is the best answer I can give you. If you're wanting to change orders and you're not sure whether or not you need to go back to court, this area of law is so fact sensitive, and it's based upon the presentation of the issues to the judge in the proper way. You definitely need to see an attorney before you make the decision, do I need to go back to court? I've certainly seen cases, Bishoy, where people have filed for modification of custody. They go into court because they think they're going to get more time, and they walk out with less. So the short answer is, don't do anything without the advice of counsel when you're talking about custody.
And if the other side keeps threatening to take me back to court and I don't agree, should I file first to preserve my rights?
Again, it's going to depend. It's going to depend upon what the specific facts in that case are. Sometimes it's strategically advantageous to file first because perhaps the person has, I don't know, a recent arrest. Perhaps they have a spousal abuse case. Perhaps they have a substance abuse problem. There's a myriad of reasons why you might want to file first, but it depends. It could be that you're better off to let them take you to court and then make the argument that nothing new has happened, that there is no change of circumstances, that the orders are working, they're in the child's best interest, and you want to preserve the current court orders.
So based on your experience, how long does this process typically take?
That is the $100 question. You could agree, and it could be almost instantaneous. It could be a matter of a few days, or you could end up embroiled in a very hotly contested custody battle that could take a couple years, frankly. If you end up hiring experts and you have to have a trial, and maybe you have counter experts because you don't agree with the first set of experts, this process could take many, many months. I could say that on average, if you have a simple case, the process is typically between 3 to 6 months.
And based on your experience as well, do you recommend having an attorney review the paperwork, prepare the paperwork, and represent you?
Absolutely, 100%, even if you don't go to court. So us as attorneys, we do two things. We give legal advice and we represent our clients in court. But even if you're not going to go to court, even if you think that you and your co-parent have an agreement and you think that everything is smooth, you still should have an attorney draft the paperwork, because the terms, the way that it's worded is going to be so incredibly important. And the other attorneys in the panel are going to talk about some of the pitfalls of custody orders. It needs to be drafted by an attorney so that you can eliminate as many inconsistencies or questions as possible. Any room for disagreement most likely will end up ultimately at some point in disagreement. But if you are going to court, absolutely 100% you need an attorney. I can't tell you how many times I've seen, and I'm sure that the panel has seen, people walking into court unrepresented with a very solid, a very good factual case. But because they're unable to present the issues and the facts in the proper manner that the court's looking for, they end up with results that should not have happened.
So hiring an attorney can obviously be costly. On average, how much do you think it costs to file or defend against a modification of child custody?
I can't give you an average. What I can tell you is it will be incredibly expensive to get an attorney. It's going to be several $1,000s. It's going to depend again on how long the process lasts. If you're agreeing, obviously it's going to be much cheaper than if you're litigating and you go to trial and you have to hire experts. What I can tell you though is people will splurge on a new purse, they'll splurge on a new wallet, they'll splurge on a fancy dinner. This is one area that you don't want to scrimp. These are your children you're talking about, and you want to make sure that you give the children, your children, the best possible chance at becoming well-adjusted, successful children. And having a custody order that's in their best interest is going to be incredibly important during their childhood. So spending the money at the front side, getting an attorney that's going to get the orders that are best for your children is going to save in therapy and bail money and lots of other things in the future.
Thank you, Gina. Colleen, I want to bring you in and talk about the process. Gina briefly mentioned it. Can you tell us in more detail what the process is?
Sure. Well, someone has to file a motion, another request for order asking for a modification in custody. And then, so if you are the requesting party, you take your RFO, you file it with the court, you obtain your dates. There's going to be 2 dates. One for return on in Riverside County, it's CCRC, Child Custody Recommending Counseling. In San Diego, it's called Family Court Services, FCS. So you'll get that date as well as your new hearing date. You then take that conformed copy. Conform means that it's been stamped and signed by the judge and all the dates and everything are filled in. You need to serve it upon the other party. And there is a very specific way in which you have to serve a post-judgment modification on the other party, which you don't want to screw that up because you got to make sure you do service correctly. And then at that point, if you're the party filing the RFO, you wait for your court date or for your CCRC date. And if you're the party receiving or been served with a request for modification, you've got to be very careful that you file your responsive declaration and present your evidence timely. So you don't want to blow that deadline. You want to make sure that you get your side of the story into the court and serve it on to the other party as well. And there are some strategic things involved with filing your responsive declaration. Perhaps you want to make sure that the mediator that's assigned to your case reads your responsive declaration because they're supposed to review the file ahead of your mediations. So then they kind of have an idea of what's going on. So you got to make sure all of your ducks in a row and you're very organized. So then the parties attend CCRC and then the or Family Court Services. At some point between your mediation and your hearing date, you'll receive a copy of the recommendations from CCRC, and then you appear at your court hearing. That's the really simplified version of that.
So on average, based on your experience, if there were prior orders made, how long does one party have to wait before requesting a modification?
That's a really good question, and it's a question we get quite frequently, especially if you have a party who's not completely satisfied or did not agree with the previous court orders. And the answer is, which is a very common answer in the practice of the law, is that it depends. Because, yeah, as Gina was mentioning, there needs to be some new set of facts, something else that's changed as to what would warrant a modification of child custody. Also, you don't want to be the party that's just is filing motions to file motions because you don't like a court order. The judge and the mediator are going to, you want to avoid a situation where you're being labeled as potentially being labeled as a problem litigant, because that's going to change your character or how you present yourself with the judge. So you really have to have a good reason want to go into court and modify your court orders. And that's again where you can sit down and talk to an attorney as to why you believe you should file the modification. So there's no hard and fast rule as to you've got to wait, a certain amount of time, because it's fact driven. It just depends on the circumstances involving your child or your children. And with that said, will we see the same judge when we file for a modification? That also depends. So judges at least here in Southern California, they're on rotation. I believe they get rotated every 3 years. You'll be in the same department. More than likely, you may not have the same judge. It just depends if the judicial assignments have changed since the last time you've been in court. And what about the mediator? Will we be given a new mediator? You may. It's the same situation. I know in San Diego County, they try to keep it with the same mediator if that mediator is even still working there. I'm not sure if it's the same rule applies in Riverside County. It just depends on the staffing and who's available to handle your mediation. Can we request a different mediator? You have no say in that situation. Otherwise, everybody would be putting in certain requests for certain mediators all the time, and that's just not a function that we're able, or a request that we can put in as to our preferred mediator at the courthouse. What about the judge? Can we change? If we don't like the judge, can we ask to change or to move our case to a different department? Unfortunately, no. There is a way you can only request to change your judge at the very beginning of the case, and there's a very short time period, and you have to have very specific reasons why. But most of the time, you are not going to be able to change your judge for most reasons. So, unfortunately, no. And what about if I've been served with paperwork, and in reading through the paperwork, I see a bunch of lies in the paperwork? What happens then? What can I do? Well, that's happens very commonly, and that's why you can't sit on a request for order or a declaration that you find to be inaccurate. You don't want to be in a situation where you just appear at court and you didn't file anything. If there's some gross and misleading statements, you want to make sure you address that. And that's where hiring an attorney to help you with this is to organize and present those inaccuracies in a responsive declaration or reply declaration, and bring that to the court's attention and the mediators, because the mediator, depending on when you file your declaration regarding those misleading statements, you can present evidence as well to the court, and you want to make sure that you do that in the way that the court, as we've discussed in prior podcasts, that you're speaking the legal language of the court and addressing or bringing those misconceptions or misleading statements to light in a way that's going to impact your case. Can the other side be arrested? Obviously, all documents submitted to the court are under the penalty of perjury. So if they're lying, they'd be committing perjury. Can they be arrested for that? That's outside the scope of family law. I know that the court, you can ask for sanctions in regards to that if the court makes a finding regarding perjury, but being arrested, that's in the criminal realm, and that would require the DAs getting involved in filing an action on that end. So your suggestion is, if you notice lies or if you come across lies, make sure that you outline your side of the story and make sure that it's detailed and in your declaration when you're responding. Oh, absolutely. Absolutely. And that's where, again, being strategic and really spending we spend a lot of time with the formatting of our declarations as an attorneys, because we're trying to, I can't tell you how often I've seen declarations where they're single space, all one paragraph, and they're like 10 pages long. That's indigestible to a judge or anybody. You just see that all that text and your eyes roll. You're not going to be reading it like that. So we spend a lot of time formatting our declarations so that it's presented in a way that gets the attention of the judge. The judge understands what the issues are, and it's not pages and pages and pages and pages of information that they are just scanning through anyway. So yes, you want to make sure that you highlight all the inaccuracies and the lies, the misleading statements, and provide the evidence. Like, for example, one of the most common pieces of evidence in modification in child custody hearings are talking parents, screenshots, or text messages and emails and calendars and those kinds of things. You have the opportunity to present that to the judge. So absolutely, it's very imperative that you do that.
Thank you. I want to shift the focus on the child. So what if the child in the action wants to be heard?
Okay.
Can they be heard?
Yes, they can be heard. There is a strong preference. Everybody wants to protect children from being involved in the court process if possible. So there's other avenues to get a child's input. Kristy, as she's mentioned in other podcasts, she's minors counsel. So sometimes the courts will appoint minors counsel to get a child's input and their perspective, and minors counsel is able to present that and represent the child without the child actually being physically in the courtroom in front of his or her parents and having to testify, but still getting that information that can be vital and very important to a judge making those kinds of decisions. There's also getting the children interviewed by the mediator, and it's the same type of situation where you're still able to get that information from children and presenting that and getting that into the report for the judge to consider and for a mediator to consider without having the children come into court, having to testify, and putting them in a very difficult position of having to do that in front of their parents, being put on the witness stand. Another thing is that judges can interview, so to speak, or get testimony from a child in their office. So they're not actually on the witness stand in front of their parents, terrified or stressed out. And I know Kristy could probably speak more about this too with her experience involving children in litigated cases. Sometimes it's necessary, but we do want to try to protect children as much as possible from having to be involved inside of the courtroom. So there are other avenues that the children can be heard and their input be considered by the judicial officer.
So at what age are the children's wishes considered?
12 is the magic number.
Okay, can you elaborate a little bit more on that?
Well, so it was, I can't remember how many years ago, but several years ago, there was a task force for the Judicial Council in California that modified that children their wishes are supposed to be considered at the age of 12. I have seen children being interviewed by mediators much younger than 12. So it just depends, but 12 is supposed to be the age in which they're supposed to be heard in these cases.
So will the child at 12 have to speak with the judge?
No. It's not an automatic requirement that if your child is over the age of 12, they've got to come into court and they've got to be able to testify or whatever the situation is. It's just that if it's necessary, the court should consider what they're requesting or being heard. But again, it's through the same channels that we're still, regardless of the age of a child, that's not the preference, is to have a child involved in these litigated matters. So it's, again, going through the same channels as I just talked about before, getting them interviewed by a mediator, minors counsel if necessary. It's certainly the last choice. I know of a lot of these judicial officers is having children testify.
So since 12 is the magic number, will the child's wishes be automatically followed by the court?
No, not necessarily. But at least it would be considered. I mean, it just depends on the situation and what's the case, what are the facts and what's going on with the child.
And based on your experience, if we don't want the child physically present in court, can the child write a letter to the judge?
We still work within the parameters of evidence, and having a letter from a child may not be admissible. It's still considered hearsay. In that situation, my advice to my clients is, rather than a letter, let's see if we can get the mediator to interview the child. Because in that way, it doesn't seem that you're coaching your child to write a letter to the court and involving your child like that. But there's certainly other ways, as I discussed, in getting the input of a child if it's necessary in your modification or your child custody hearing.
Thank you. Let's talk about reaching an agreement. So what if the parties have a pre-existing court order but agree to new terms? Do those terms have to be in writing?
That's a good question. I would always suggest to put your new agreement in writing, and then also to put it, not just stop there at putting it in writing like text messages or whatever, but to get it into a stipulation so you have an enforceable court order. And that's really what's going to drive this home and really protect your rights, because the last thing you'd want is that you believe you're operating off an agreement to find out it's not enforceable and there's nothing you can do about it. So if you run into an issue, you have nowhere to go with it other than we wrote this in an email and we've been practicing this. That's not getting you 100% of the way there. That's great that you have an agreement, but not only should it be reduced to a writing, but it should be reduced down to a stipulation where both parties sign and a judge signs it. And now you've got a court order that's enforceable.
And what about, let's assume the parties don't agree at the beginning, but agree at mediation. You mentioned that it's a two-step process. First, you see a mediator or a counselor, and then you see the judge. So if they agree at mediation, do they still have to appear before the judge?
Yes, because again, your agreement that you reach at CCRC or FCS is not a court order yet. The only person who can make it a court order is a judge. So you've done all the hard work, and congratulations, you guys reached an agreement, but you need to get it over the goal line, and that's going to the court, adopting it as a court order, and having that in your hand as a court order.
And what if the parties or one party doesn't agree with the mediator's recommendation then?
Well, so you have some options. You certainly, when that occurs, at least in my practice, depending on when you get the CCRC recommendations, either if you have enough time, try doing a declaration outlining why these recommendations are simply not feasible, information that the mediator perhaps didn't look at or didn't consider, but then ultimately you're going to need to argue that at court and present that at court as to why these orders are not going to work for your children. And that's, I think, the biggest thing to think about when you're going through a modification or contemplating a modification for child custody or visitation is looking at it through the perspective of your child or your children. Why is this not going to work for your children? Not for you, but for your children. And I think that when you're looking at these issues from that perspective, rather than just, this isn't going to work for me, that it has a bigger impact on the judges, and they are more receptive to that, rather than saying, I don't like it because it doesn't work for me, it's inconvenient for me, but rather, let me explain why, with giving, this is my child's schedule, this is what their daily schedule looks like, and this is why this particular visitation plan doesn't work for them. I think that resonates better having it come from that perspective with the judge.
And what if one party does not agree with the judge's orders?
Well, so then I think I've talked about that before. Judge's orders are judge's orders. You would then have to, the only way to change them is either through a stipulation by both parties, or you file a modification at some later date to change those court orders. So unfortunately, that happens quite frequently, is that somebody is not happy with the orders made in regards to visitation, but they're court orders. And so the only way to change them, like I said, is either that the parties agree to something differently, and I would suggest putting that in writing and into a stipulation filed with the court, or that you then request to modify those orders at a later time, that you have the required legal standard, so to speak, in order to change them.
Thank you, Colleen. Kristy, I want to bring you in on this topic as well. So let's say that there were pre-existing court orders. The parties file for a modification, court orders are made, and one party does not agree with that court order. Can they then turn around and agree to something different?
B, they absolutely can, but I want to back up just a hair, and I know I always do this. I really want the message to be understood that, and Colleen said it in terms of my experience as minors counsel, you need to tread very, very lightly when it comes to involving your children in the litigation. I've seen it numerous occasions where there are letters submitted to the court from the children where, you know, and all of those processes or all of those decisions to involve your child, you have to weigh the result. And I'm telling you that don't think involving the children at all, unless you consult an attorney of how you need to do this, you should be doing it whatsoever. But with that said, yes, if you don't agree with the court orders, I think we need to make a distinction here. I think we're bypassing the CCRC process. So the CCRC are going to make recommendations. If you don't agree with those, then obviously you need to have an evidentiary hearing and present your evidence as to why you don't agree with the recommendations. Now, after that evidentiary hearing, the court makes orders and you don't like them, then as Colleen aptly points out, you're gonna have to, first you're stuck with them unless you want to appeal them, but that's a whole different conversation and not something that is really done that often because the standard is so high to be able to appeal those orders. But the other avenue is going to simply be a modification at some later time or agreement.
And will the other side automatically get 50-50 when they file for a modification? That seems to be a common misconception.
Well, I don't even like the word or terminology 50-50. I feel that that's a financial term and it comes up quite often. I want 50-50. I don't want them to get 50-50. And that's literally a percentage that's put into a child support calculation. The question is, what is 50-50? What is sharing equal time? What does that look like on a calendar? And why is that in the best interest of your child pursuant to continuity, stability, all of those things? So no, there is not a rubber stamp of whatever 50-50 means that the court, just stamps on whenever you go to court. So it will be based on the facts of what the particular case is. I see this often where someone has, for instance, a schedule of every other weekend, and then all of a sudden the primary custodial parent receives a request for order from the other parent, now wanting a week on, week off basis. That happens a lot. And when that happens, obviously you don't think it's in the child's best interest because they've had this other schedule for so long. And the other parent is doing it because they think it's in the child's best interest because the child maybe expressed to them that they want to spend more time with them. That's why it's important to hire an attorney to navigate you through this process, not only filing and drafting the paperwork, but you're probably going to require some type of evidentiary hearing. And that is my area, which is the litigation aspect of this, and hoping that you present your case well enough with your evidence that whatever orders you're seeking, those are the ones the court follows. But no, it is not a guarantee whatsoever.
And based on your experience as minors counsel, what if orders are made but the child does not want to go?
That's a tricky one. First of all, a child never gets to really make that decision. I'm sorry. You have to force your child to eat their broccoli. You have to force your child to go to school. You have to force your child to, get off their cell phones. Whatever it is, we are the parents. So it is incumbent upon us to make sure that we follow the court orders. If your child does not want to go, then that is a basis as a request to see if you can modify those orders. Get to the bottom of why the child doesn't want to go. But no, I would never advise anybody to violate the court orders in spite of the fact that the child doesn't want to go. But if there are safety concerns, clearly that could be addressed on an emergency basis. My child doesn't want to go because, God forbid, they feel suicidal or have suicidal ideations in the other parent's home, something like that. We can address that on an emergency basis. If the child is, the child's age, so say for instance, the child is 17, that might be a different set of facts. They've got a busy social life. They don't want to have to, adhere to all these visitations because they want to hang out with their friends. That might be something that we can enter into a stipulation about. So it really depends on the facts. But if a child just simply says, I don't want to go, the parent has to force the child to go, I believe, until that order is modified in some way. But
So if I understand you correctly, age is a huge factor in making that determination for you.
oh, it absolutely is. But I've been minors counseled to children that are, 4, 5, 6. Their needs are different than someone who's, say, 16, 17, 16, 17, 12 even. It really depends on why. Why is the child refusing to go? And that is a question that you need to sit down with competent counsel and explore. Because if you file something in pro per saying, my child doesn't want to go, and so therefore I'm not making him go, that might get you in trouble with the court. I think you really need to parse out the facts of why this is happening. It may be that the child needs counseling. That might be the best result here, and not specifically modifying the orders. You may get that agreement with the other custodial parent regarding like a pause in the visitation. So there's just so many moving parts to that issue. But like I said, as an officer of the court, I would never advise a client to violate a court order and not make the child go.
Thank you for that, Kristy. What if the orders say by mutual agreement? What does that mean by mutual agreement?
That's usually a result of poor drafting, okay? When we all start out in the beginning of these custody matters, I see this happen a lot with pro pers, where they don't want to do the work to come up with a very particular schedule. So they make it very vague, very broad. Oh, we'll figure it out. Holidays, we'll share them by mutual agreement. But I've gotten the call on Christmas Eve. The parents said that they would return the child at 9 p.m. I'm sitting here, the child's not here. I called law enforcement, and the law enforcement says, well, there's no specific order, so you're just kind of out of luck. So that happens quite often. And like I said, especially when people represent themselves, because they don't know the language, they don't know what to put in there. So in that particular instance, I believe that Gina addressed that that's going to require a request for order to clarify the orders. This is what we are doing in the past. Now, for some reason, the other parent's not doing that. I need a specific order about whatever that is. And especially as it relates to the schedule, like the parenting schedule. And it's by reasonable right of visitation to both parties. I mean, what does that mean? But the court's going to look to the continuity, what you've been doing. And usually they will say, why don't we continue something like that? But yeah, those orders require a clarification with the court in terms of a modification.
And do you hold the position with reasonable agreement or reasonable visitation?
What do you mean by that, B?
If the order says that visitation is to be by reasonable agreement, or visitation is to be, or the schedule is to be based on reasonable visitation, between the parties.
So I believe that there is a slight nuance or distinction between reasonable visitation and just mutual agreement. I think reasonable visitation holds the parties to a higher standard in terms of what, they have to be reasonable. I think if it's just by mutual agreement, then, again, there is this reasonable standard, but, it has to be agreed upon. I think those orders, all of them require clarification and some sort of modification.
And what if one party follows the court order, but the other doesn't? If one party, let me rephrase, if one party does not follow the court order, do I have to follow the court order?
I would say yes. You always follow your court orders. If you cannot agree and it is not in writing and hopefully a signed stipulation, you need to follow your orders, period. And if the other side's not following their orders, then that's the basis, can be the basis of a modification. But you don't want to be the one going into court looking like you have not followed the orders. It's a bad look. Judges don't sit all day and hear these cases and take their time to come up with their orders just so you ignore them. So if you come to court with unclean hands, it might impact your ability to be successful. So follow the orders and file your modification. Preserve your right to make changes or whatever it is that you need to do.
And if one party constantly requests to change the times and days of the visits, do I, as the other side, have to agree to those terms, to those changes?
You don't. You really don't. And I get this a lot where one side is very reasonable and malleable. They'll flexible. That's the word I'm trying to look for. Flexible. And so then the other parent isn't flexible. For instance, you know, one parent wants to go on vacation. It's during my custodial time. They agree, you know, that parent agrees to let them have the child. And then when they want some sort of favor because they've got a special event they want to do and the other side won't agree. That's a constant theme in at least my cases. And, you know, I always tell the parents, this is about your kids. This is about your kids having an amazing childhood. So yeah, while you may be more flexible, if it's in your child's best interest, continue to be flexible. But if it's becoming impeding and there are things that, you know, you have planned and you simply can't agree to this request, then you don't need to. And you don't have to justify yourself. It's just the court orders are there to be your guide. They're there to guide you when you as parents can't agree otherwise. They're the default. So at the end of the day, if there's any issues, then you know you need to just follow your orders.
Thank you.
Or get them modified.
I have one more. Sorry, there's an echo. I'm not sure if it's on my end. Give me. Okay, let's try it now. So I have one more vague question for you. What if one party moves away? How does that process play out?
Well, you have to look to your particular orders and what the process is for doing something like that. And then it depends on whether or not you agree. So if you and the parent have sat down and agreed that the move away is a good thing, then obviously you just need to come up with an agreement about what the parenting time is going to look like now that this move has been had. But if you don't agree, then obviously, you know, you're going to either have to file a motion or they're going to have to file a motion based on, you know, what the court orders say. And so that issue will be litigated.
And then the last question for you is there a way to, I know Colleen talked about the process in great detail and she indicated that there's 2 dates that are set, one for mediation or CCRC and one for the court. But is there a way to speed up that process if I'm worried about the child's safety or health?
Absolutely. And I think I hit on it just briefly, is that if there's an emergency that exists, whatever that may be, whether it be a health issue, a safety issue, those are things that can, I like to call it cut in line. You may be able to cut in line and get your issues heard and before the court prior to those dates, for sure.
Perfect. Kristy, any final words for our viewers?
Well, I think that one thing that I wanted to point out that Colleen was talking about in terms of, okay, you went to CCRC and you came to an agreement. It is very, very important that you go to that court date. Most people think, oh, we came to an agreement, it's with the court, whatever. And I've seen so many times where one side shows up and the other side doesn't, and because they think they have an agreement, and the judge asks, is this still your agreement? And the party says, ooh, I might have a second bite at this apple, and they may say no. So then the judge asks why, and then all of a sudden this could go south, and you you may get mailed a different order than what your agreement was. So it is extremely, extremely important to go to those dates, be prepared for those dates. Don't take anything for granted in the court process. And the second thing I would say is, again, just to reiterate, because my work as minors counsel is a very special aspect, or has been a very special aspect of my career. And I would just say, be mindful of the kids, be mindful of their feelings. This is about them. This is what's in their best interest. It's not about you, it's about them. So when you file these requests, or you want to get your children involved in this process, just please, I implore you to be child focused in that regard.
Thank you, Kristy. Colleen, any final comments?
Oh, there we go. I was gonna unmute myself. I actually don't have any other comments. I think I guess I do now that I keep talking. It's just, I think it's hard for a lot of litigants, a lot of parents sometimes just take a bird's eye view of what's at stake. And I think what Kristy's saying, you know, keep your kids in mind, you know, especially as it gets difficult to co-parent and you don't want to be flexible anymore, but think about what's in the best for your children. And sometimes it's taking the high road and doing that, even though you don't want to do it anymore, and to reduce conflict, because it has a bearing on your children. So just be mindful of all of those things. And then also ask yourself, if you are contemplating or in the process of modifying your court orders and looking at some of your own behavior, how is this going to be viewed by a judge? Especially with some of these text messages and Facebook posts and things like that. So sometimes the best response is just taking the high road in these things.
Perfect. Thank you, Colleen. Gina, any final comments?
Yes, playing off of Colleen's comment about taking a bird's eye view. We've talked a lot about being flexible, but I want to take the other side of the coin here and talk about people who are too flexible out of guilt. As attorneys, what we can do is give you an impartial assessment of what we think is a fair order. Because many times parents have an imbalance of power where one side is bullying the other and using one parent's desire to give the children a fabulous childhood as a way to constantly modify the orders and to create chaos in the lives of the parties and of the children. So if you are going to modify orders, if you are experiencing difficulty with the other side, if you are, let's say, agreeing to stuff that you feel uncomfortable about, you might just want to pick up the phone and give us a call so we can kind of give you a rundown of what we think your situation is, and to help you out is to determine whether or not you need to go to court, or maybe you just need to stick to the current court orders.
Thank you, Gina. And I really want to take this opportunity to thank the legal panel for sharing this great information. I do want to remind the viewers that we will be posting this on our social media websites, YouTube, Facebook, and our website. And if you do have any questions or contemplating filing for a modification, just pick up the phone, give us a call, talk through your options. Our phone number is 951-587-0505. You can also reach us via email at info@TemeculaDivorce.com, or you can simply visit our website, www.TemeculaDivorce.com, and request a consultation from there. I do want to thank you guys once again, and God bless.
God bless.
Bye.